Guys, Miss Parnell back for the second part of notes that goes after criminal cases. Now we're just going to talk about criminal law. All right, so criminal law, first off, what is the purpose of it? Well, the first purpose is to make someone pay. I mean, we figured this out when we were kids. Someone does something wrong to us, you want them to pay, punish, go to timeout and think about their actions, lose out on this, miss having this. Whether you're taking their money from them to pay back the damage they did, you're taking their time, you're taking their freedom, you're taking their whatever, it's to make them pay. All right. The second part is you want to protect society. Depending on what the person's doing and how bad it is and how serious, like, are they just out like a serial killer, just out there killing people or, robbing people with no care to who they harm? Like, we need to keep the rest of us safe from this person, right? So protect society from the criminal. Warn others not to commit the crime. Again, this is probably something we learned as a kid. You see someone else do something, you're like, ooh, I don't want that to happen to me, so I'm not going to do that. And maybe you thought about doing that, maybe I was going to go out tonight and rob someone, but then I just hear what just happened to my friend who did it, and I'm like, well, I don't want that to happen to me, so I'm not going to do it. So it just kind of warns others, like, this is what's going to happen, so do you really want to steal that watch from Walmart? Because is it really worth sitting in jail? And I'm like, no. And the last thing is to rehabilitate the criminal. Now, this is actually kind of one of the major ones too. So it's kind of one of the ones we overlook. Like, people don't think of this, but like, the major thing is we don't want someone to sit in jail forever. But let's be real, who wins? Does that person win? No. Do you and I, the people that don't even know them, paying their upkeep, every meal, everything with our taxpaying dollars every single day, are we winning? No, that's money. And think about their family, their friends. Do they have kids, spouse, parents, whatever? Like, are they winning by having this person just sit and rot in jail for forever? No. So like, the main goal actually too is to rehabilitate, because you want the person to like realize what they did was wrong, realize why we don't do that, come to find better ways to do things. Maybe if they're on drugs, get them off so that they don't have to go steal from people to get money for them and stuff like that. And then they can return to society and hopefully be a better person. Now, some people don't. They go back out in society and do it again. They just come right back to jail. And some people just do that over and over again, or it gets to the point where, you're like, okay, obviously you're going to keep doing this. So you just have to sit in jail for a long time. So now let's go through every step in the trial. So the first step is an arrest. All right. So the suspect is arrested for committing a crime. They're taken to a police station. They're charged, which is called booked. Back in the day, they used to just write it in a book, which is where it comes from, like book 'em. They give their fingerprints. They give their photograph, aka a mugshot, and they can be allowed to call a lawyer. They get to make, a phone call to someone. Now, this does not always mean the person did it. Sometimes, as you know, people are unfairly arrested for suspicion of committing a crime, and then it later gets proven they didn't do it. So this doesn't like automatically mean guilt or anything. Pretty soon, they're going to have a hearing. So they're going to be taken, usually they're like kind of picked up, put in a jail that has kind of like a magistrate's office or something. I might not even be saying this right. If somebody's watching this, they may know better than me, but it's like has a place kind of attached to it where you can have a hearing with like a judge or a magistrate or something. They have to show probable cause. So if they arrested me last night, they arrested me last night. This morning I wake up and have my hearing, and they have to show why they arrested me, and it has to be a good reason. Again, it can't just be like, oh, Sheets just got robbed by a white lady, and I'm just happen to be walking down Glen High Road, and I'm white, and they pick me up and take me to jail. Like, it can't be like that. Like, you have to have more. She had brown hair. She was this tall. She was wearing a gray shirt with this. She was running in this direction. She had this. This is how much money she stole. So when you empty and find my pockets, that's how much money's in it. They have to have a lot of reasons. And they present that to the judge. Based on what they got and like what the person's being accused of, is one of three things is going to happen, okay? They're either going to get sent back to jail, no bail, wait until the trial. They're going to get a bail set, and the worse off what they did, the higher the bail. But if you pay the bail, you go home. Or if what the person did wasn't that bad at all, then they can just go on and be released. So it just kind of goes from like what you did, was terrible, to what you did was like not a big deal at all. So obviously if someone's picked up for like murder or something, they're not going to get a bail. And if someone's like a serial killer has been picked up, they think they've killed like 5 or 6 people, like they're definitely not going to get a bail, because we don't want them to go out and pay the money, go back out into society and kill 5 more people, right? So if it's really, really bad, sometimes murder, rape, stuff like that, really bad assault or something like that, maybe they're just going to sit in jail and wait till their trial, no bail. If what they did was like medium bad, and it goes from high medium to low medium, high medium would be like a high bail. I mean, you've heard of people having like $100,000 bail, $1 million bail if what they did was really bad. Sometimes they just have like a $5,000 bail if it was just like a drug offense that they're like a repeat doing or something like that. But if you let them go, they're not going to harm anyone. They're just kind of not making good decisions. So if they'll set a bail, and then if you can pay the bail, you would go home. If you can't pay the bail, you just sit in jail and wait for the trial. And like I said, if it was just stealing a watch from Walmart and you're like a first-time criminal, no criminal record, nothing bad, didn't harm anyone, you know, a lot of times if it's teenagers or kids, they'll like release them back to their parents, and you just come back to the courtroom when it's your trial or something like that. But there would be no bail set. So that's one of the three things that the judge is going to decide: no bail, bail, or no bail and you stay, bail, pay it, you go, don't you stay, or just go. All right, indictment. So this does not happen in every case. Only some cases have it. So a lot of cases skip from step 2, what you're going to see in a minute with step 4. Only some have this step 3 in the middle. So indictment is when they do a grand jury. So basically, I think I talked about this when I was talking about the amendments and the Fifth Amendment with indictment by a grand jury. It's one of your rights in the Fifth Amendment. So let's say I'm on trial for something really, really bad, okay? Before they put me on trial, because remember with the double jeopardy, they get one shot to show I did it, okay? They get one shot. And if they don't prove that I killed so-and-so and I get let free and let go and I go kill more people, that's terrible, right? So they want to make sure they prove I did it so they can lock me away. So before they do that, they want to make sure like it's a sure bet. So they get this grand jury before a trial, and basically only the prosecutor shows evidence. The person does not get to defend themselves, but it's not a real trial, which is why they don't get to defend themselves. Prosecutor shows all the evidence. We have this, 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 and this. And the grand jury is going to look at it and be like, oh, yeah, man, looks like great. Go to trial. You got a good shot. Or the grand jury is going to look at it and be like, you know, you don't have an eyewitness, or you don't have a murder weapon, or you don't have any DNA. It's kind of looking like the person might get off. Like, it kind of doesn't really, it's not 100% sure bet the person did it. So that's what an indictment is. It's only for very serious crimes and stuff like that. So if not, they go straight to arraignment. So this is when the defendant would appear back in court and be presented formally with the charges. They formally say, this is, and you know, you've heard on the news or on TV shows, they'll like start throwing some more charges on there. They'll find out more things in their investigation. So this is when the person's formally presented with all their charges that they're up for. They would be given a lawyer at this time if they can't afford one. It's a public defender. Talks about this, you know, with the amendments and the Sixth Amendment. You gotta remember, you get what you pay for, right? So like the free person that works for the government is not going to be as good as the slick talking, you know, fast talking lawyer that's on the billboards driving around in a BMW that you have to pay $1 million to get. You get what you pay for in life. You know what I'm saying? So that's why, you know, like O.J. Simpson had like, you know, Robert Kardashian Sr., you know, of the fame, the dad, the paternal father of the Kardashians. He's a lot different than like the free person you're going to get in Winston-Salem, North Carolina. Okay. And so some people say that's why people are able to get off the hook, because they have a fast talking, really smart, slick lawyer, you know? So just kind of keep that in mind. But again, it's better than nothing. It's better than, you know, someone having to defend themselves, right? And the defendant would have to enter a plea. They say, not guilty. I did not do it. Well, obviously, you say you didn't. I say you did. Well, let's go to trial and figure it out. So most people do say they're not guilty. Very few people get arrested and are like, you know, like most people do try and fight it, whether they're right or wrong, whether they're lying or not. And there's some people not lying, like they really didn't do it. But there's some people who did it, who said it didn't. But either way, not guilty is what happens, and the case continues and goes to trial. Guilty, they would stop right there and just sentence you. No point in going through a trial. If the person said they did it, let's just go on and punish them and move on to the next one. Then there's something called like no contest and a couple other things, but we're not going to worry about that. So in the time leading up to trial, now the bigger the trial, the bigger the offense, the bigger the thing, right? Like murder or something like that, the longer the time period until trial, because they need to make sure they check everything. They check with all the witnesses, look through all the bank records, go through all the cell phone records, look at all the surveillance video. I mean, there's so much stuff investigators have to come through. If it's something little like stealing from Walmart and it's on like security camera and it's like, come on, then, you know, it might just be like a couple weeks until trial. If it's murder or something like that, it could be months. It could be like a year until the person goes to trial, because the lawyer's doing things, checking facts, gathering evidence, interviewing witnesses. This is when lawyers start to talk. You know, it's like anything, it's a game, right? It's a competition. And so the lawyers talk. And so, you know, If I'm the defendant, my lawyer may come back to me and be like, look, Ms. Parnell, I'll be real with you. They got this, 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 and this. You know, they got this person saying they saw you there. They got your hair from the murder scene. They got a picture of you on the surveillance camera. They got, you know, your friend saying you told them you were going somewhere. And I'm sitting here, especially if I did it, I'm sitting here like, whew, sounding like they're going to get me. So a lot of times people do plea bargaining. And so they'll say, look, if you just go on and say that you did it and wrap this up, like if you save the courts time, effort, energy, money, like they'll go easier on you. You know what I'm saying? It's kind of like if your parents say, like, you just tell me the truth, I'm not going to punish you as hard, right? If you go through this big elaborate lie and then they find out, oh boy, it's going to be a whole lot worse. Kind of like that with the courts. If you just go in and tell us you did it, they'll do an easier punishment. If you make us waste our time and go through all this trial and days and months and money and lawyer fees, and then we still find out you did it, they're going to throw like the book at the person, right? So a lot of times, especially if somebody knows they did it, they'll take a plea bargain to avoid, you know, instead of like, look, if you go to trial, the max, you know, you can get like 30 years in jail. You're sitting here like, well, you know, and they say, but if you just plead guilty right now, it'll be like 10 years. Well, especially if the person knows they did it, they're probably going to take 10 over 30. And especially if it looks like they're really going to get found guilty, like it looks like they have a lot against them, they're probably going to take 10 over 30, right? Also, subpoenas are documents that are sent out this time requesting someone appear in court. So you could get a subpoena in the mail. You could have to go to court and testify, like against your best friend or something like that, which is pretty crazy. Obviously, you know from the amendments PowerPoint that you have the Fifth Amendment. You have the right not to talk. You can plead the Fifth. You can stay totally silent. You do not have to incriminate your best friend or something like that, but you can't lie. It's perjury. So if you get found guilty for lying, then now you'd be in your own, have your own set of problems, have your own trial, your own criminal things. So definitely against that. But a subpoena, you know, it comes in the mail, and it actually, I think a sheriff delivers it personally too. And it says you have to be there. And if you don't come to court on that day at that time, like they said, then a warrant's out for you now because it's failure to appear in court. And they take that stuff pretty seriously. If they come to court at a certain time, you don't come to court at a certain time, not good. And so that's how they get like witnesses and stuff like that. Then they try and select a jury. So they call residents, randomly called for jury duty, and lawyers pick from the group. I think I might have talked about this in the amendments PowerPoint because you get the jury with your Sixth Amendment. But I'm not sure, so I'll probably talk about it more in depth again. So residents are called. Either side can dismiss a juror for any reason. So like, here's the thing. You don't want a jury that's all women. You don't want one that's all male. You don't want one that's all black, all white, all Hispanic. You don't want all old people. You don't want all young people. You don't want all rich. You don't want all poor. You don't want all smart. You don't want all dumb. You do not want that. You want it to be mixed up. Black, white, Hispanic, guy, girl, old, middle, young, right? Some rich, some middle, some poor, some super smart, some not so smart. Because that gives you, think about it. If I had to convince just you of something, I might could do it, right? That's one person. If I had to convince, 12, I think. Yeah. If I had to convince 12 of you in class of something, okay, it's getting a little tougher. But what if I had to convince 12 people from like this area? An old lady, an old man, a black person, a white person, a Hispanic person, a really smart person that knows what I'm talking about, a really dumb person that doesn't know what I'm talking about, a really rich person, a really poor person. Think of all the differences of people. And there's 12 of them standing together. And let's say you're one of them. It's you and 11 other people that are totally different from you. I would have a really hard time convincing all 12 of you. Like, let's say, you know, I need to convince you to go back to school. Okay. If I had to just convince you, you're like, probably right now, like, nope. I don't know. Some of you guys might want to. And if I had to convince just a bunch of people in my class, I might still get a resounding nope. Like 12 of y'all are like, we don't want to come back. We're loving it at home. But if I had to convince 12 people, like your parents or your grandparents or old people or smart people or rich people or poor people, people who couldn't watch their kids, people who are like over their kids and want them to go back, do you think I could convince 12 totally different people from society to all say, nope, don't go back to school? I don't know if I could. Even now, I mean, people seem to be like all on the same page of staying in, but let's be real. If I got 12 totally different people, you just can look online at people's comments on stuff. There's some people who do not like the stay-at-home order and don't like the governor told us to do this and think it's stupid and think we should be back at work and back at school. So that's why you want 12 different people. Because if you're the person up on trial for the crime, you want it to be as diverse as possible, because it's going to be hard for them to convince 12 different people that you did it, right? Because someone's going to have sympathy for you, right? Like the person who's your age, or the person who's your race, or the person who's your gender, or the person who's, like someone will have mercy on you or sympathy, right? And here's the thing, they got to convince all 12 in order for a person to be found guilty. So they'll dismiss people for any reason. I could come up, sit down, they could look at me and say next, and I'm like, what was it? Maybe they already got 3 white girls and they don't need another one. Maybe they already got 3 people my age group and they don't need another one. You know what I'm saying? Maybe they already got enough women. Maybe they already got whatever. They can also start asking me some questions. Maybe they start asking me questions. Oh, what do you do? Oh, I'm a teacher. Oh, that's good. Are you married? Yeah. What's your husband do? Oh, he's a police officer. And they're like, next. And I don't even know why they sent me out, why I got dismissed as a juror. But then maybe I later find out that the case was about a guy killing a cop. Well, surely they don't want me on the stand. I would be a terrible juror. I would not be, I would be biased. I think that's the example I gave talking about an unbiased jury, but I can't remember. I would be biased. Like, let's be real. You know what I'm saying? There's things in life you're biased towards. And if someone said, you got to forget about that, we would be like, I can't. You know what I'm saying? So if it was like someone killing a cop and my husband, like the person I love the most in this world, is a cop, I'd be like, I'm going to get that person. I'm going to find them guilty. You know what I'm saying? So they want it to be fair and they want it to be mixed up. And then the trial starts. So you get your opening arguments first. So each side does an opening argument. Here's the way I talk about it. Think about writing a paper. You have like your opening paragraph, you got like your paper, and then you got like your conclusion paragraph. So it's like opening arguments, whole trial, closing arguments. You know what I'm saying? Each time the prosecutor goes first. Because if you think about it, if you're like pleading your case, you can't defend yourself first because you don't know what to defend yourself up against. So the prosecutor has to go first, say all the things the person's accused of, all the reasons why they did it. And then the defendant would come up and be like, here's why I didn't do it. Here's why that's wrong. Here's to prove you I'm innocent, that type of thing. So lawyers for each side make an opening statement outlining the case. Prosecutor says, here's what I'm going to show you today why so-and-so did so-and-so. And then the defendant would get up and be like, here's what I'm going to show you today that I did not do so-and-so. Whatever it is, you know what I'm saying? Whatever they're accused of. Then the prosecution presents their entire case. Entire case. This could last for days, weeks. And like the O.J. Simpson case and stuff, I mean, it was like weeks and months. I mean, it was their entire case. And if you're the defendant, you just have to sit there, which I can imagine is incredibly hard. Like, especially if the person's not telling the truth or trying to pin you or frame you or something like that. And you just have to sit there and be like, and you can't it's like being in an argument and they're just saying all the reasons why you're wrong and you can't say anything back. So it's got to be incredibly hard. But then as soon as they're done, you hear them say on TV, like the prosecution rests, Your Honor, or the state rests, Your Honor, or something like that. Because remember, the prosecution's like the state of North Carolina or something. Then the defense gets up and says their whole side and says, remember when the prosecutor said this is why that's not true. Remember when they showed you that's not really him. Remember when, and they kind of go through and they're just trying to poke holes in the story. Because here's the thing you're going to see in a minute. All 12 jurors have to be 100%, well, 99.999% sure that the person did it to convict them. And so if you can poke enough holes in the story, if you're sitting there as a juror and you really thought the person did it, but then the defense gets up and they start telling you a couple things, you're like, I mean, maybe they didn't, right? So when you start getting a little bit of doubt in your head, then they did their job and then the person will get off, right? And so then they do their closing statement. So again, prosecutor goes first, kind of sums everything up, defense goes last. The only time that you ever get to talk, that the defense gets to talk while the prosecutor is presenting, or why, right there, so let me come back. The only time that the defense gets to talk while the prosecutor is presenting, or the only time the prosecution gets to talk later when the defense is presenting, is if they cross-examine. So they put someone on the stand, which is testimony. The person's giving their testimony. They're a witness. They're answering questions, evidence of witnesses. And after one side's done with the witness, the other side does get to get up and cross-examine them. Again, you're trying to show they were lying or making this up or poke holes in their story, create doubt so that the jury won't believe everything they said. Perjury would be if the person lied under oath, which, like I said, is a whole nother can of worms. Bailiff is the sheriff in the courtroom that keeps order, especially if there's an outburst, somebody gets out of hand. I mean, a courtroom's a very formal place. You can't say anything. I mean, even things that you and I think aren't that bad that wouldn't even get you kicked out of a classroom, get you kicked out of a courtroom like that. wearing something, doing something, those kind of things, the bailiff will take you out, which would be being held in contempt of court. And that's basically like a jail cell in the courthouse that the person sits in while the trial's going on because they can't get it together enough to be in the courtroom. Excuse me. So after the case, after, closing arguments and the case is over, the jury goes to deliberate. So the 12 jurors go away. They are in secret. No one is with them because that person could be biased for either side. No one is with them. So there's like a head juror who's like supposed to be in charge of the others. Like, all right, guys, let's start voting. Let's start talking it out. And they have to be unanimous. Unanimous means all 12 have to decide guilty or innocent. It is really hard, like I said, to get 12 totally different people to be unanimous. There's always one person who wants to hold out, or 2 or 3 people that kind of join up and they're like, no, da, da, da. So that's why they deliberate for a long time, because it usually takes hours or days to get all 12, unless it was just like an open and shut case and it was so clear the person did or did not do it. And it's like, oh my God, anyone could see that. Then maybe they deliberate for an hour and they're done or something. But most of the time it takes a while. They have to talk and figure it out. And like I said, the prosecution has to prove beyond a shadow of a doubt that the person did it. So think about it like this. If you're a juror and you're sitting there and you're like, I really think the person did it, because they said this, 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 and this. I don't really think the person did it. But man, that one witness, man, they got me thinking, and they got a little bit of doubt in my head. I got a chunk of doubt. I'm 90% sure they did it, but I got a 10% chunk of doubt in my head that like, maybe they really didn't, right? So if there's a shadow of a doubt in your head, a chunk of doubt, a discernible amount of doubt that the person did it, by law, as a juror, you have to vote not guilty. So you could think more than not that they did it. I could be sitting here thinking, I'm 90% sure that person killed someone, but I'm not 100% sure. And if I'm not 100% sure, I cannot by law say they did it, call them guilty, and put them away in jail for 30 years. Like there's a shadow of doubt in my head. I have to say they're innocent. And that stinks because, sometimes if you're 90% sure about something, like you're pretty daggone sure. But 10% is 10%. And it can't be ignored, And so that person. And so that's why guilty people do get off the hook. It's actually harder to find someone guilty than innocent. It's way easier to find someone innocent because all you need is a chunk. 5% of doubt, whatever I'm saying. It doesn't have to be like 50-50. You're really sure they did it, but you got some kind of doubt in your head. By law, you have to vote the person not guilty. While the jury's doing this, if it takes days or weeks or whatever for them to decide, especially in high-profile cases like the O.J. Simpson case, the Zimmerman case, like Casey Anthony with her daughter, some of these more high-profile, like the Bill Cosby case, stuff like that, they're sequestered, which means they are kept away from the public's eye. So they're not watching the news. They're not on social media. They're not going home to their families telling them, oh, guess what I heard today about the trial. Da-da-da-da. They don't want other stuff in their head when they make a decision. They only want them to consider what's in the courtroom, what was presented in front of them, not what the lady on the news is running her mouth about or the guy on social media is tweeting about. They don't want that to get in their head and weigh their decision. So sometimes they're sequestered. If they cannot come to an agreement, that's a hung jury. And usually a judge keeps telling them to go back and keep working. If it takes days, if it takes weeks, work through this, come to a decision. All 12 of you need to be guilty or not. But if you get it like split, 6 and 6, something like that, 8 and 4, and these 8 are not going to budge, and these 4 are not going to budge, or 6 and 6, and no one's going to flop sides, and we're not going to get 12 either way, innocent or guilty. It's a hung jury. Have to start all the way over from the beginning. Whole new trial. Called a mistrial, which means you have to have a retrial, which means you start from square one. Step one, you start from. So that's a big deal. They don't want that. It means a lot of effort, energy, money, time was wasted. So the judge usually really encourages to come to some type of consensus one way or another. And sometimes that means like one person, if you're the holdout, have to go to the other side or something like that. But sometimes there is a hung jury. That does happen. Acquittal is the fancy word for being found innocent, being found not guilty. And the way I always tell kids to remember this, and if we were in school, I'd be showing you like the cool videos and stuff because I was a kid when the O.J. Simpson case happened. That was a really big deal. That's kind of how I learned a lot about like what a trial was because back in the 90s, no internet. Really, the only TV you have is just a handful of stations at home, and they were all about this. And so that was all I had to learn about for like months, really. I went to school and like it was playing at school and stuff like the way I remember this is the big kicker kind of at the end was there was this bloody glove. So O.J. Simpson was accused of murdering his ex-wife. I think it was his ex-wife at the time. I don't think they were still married. They were estranged. They were living apart. I don't know if they were still married or not. And another guy. And they were stabbed to death. So there was this glove left at the crime scene, had blood on it from the stabs, the knife, everything. It was his glove. Well, the woman was found murdered at a house that they used to live in. Again, I don't know if he was currently living there, if they were separated, divorced, whatever. So his whole claim was like, yeah, that was my glove. I know my DNA is in that glove. I used to wear that glove. But I don't wear that glove anymore because my hand doesn't fit in it anymore. And there's no way I could have got my hand to fit in it a couple months ago and held a knife and stabbed someone. And so the whole thing was like, if the glove doesn't fit, you must acquit. And that's what they kept saying. Well, at the very end, he goes to put the glove on and it doesn't fit. It'd be like you or me trying, and it's a leather glove, so like it's not stretching. So it'd be like you or me trying to put on like a kid's leather glove, and you know how like it would have like the spaces, like you couldn't get it down, you know, like you couldn't get your fingers all the way to the end, you know, because your fingers would be too fat, it'd be too small for you. That's kind of how he looked. And so he couldn't even like close. There was no way he was showing like he could have held a knife, right? He can't get it on. And so I think maybe the jury was thinking he did it. Well, that was the last thing the defense did, or one of the last things. And it poked a hole in it, right? It put a shadow of a doubt. If you were a juror, you're sitting there, you're like, I really thought the guy did it, but daggone. The bloody glove that was used to kill the person, he can't even get his hand in. Like, I don't know. It doesn't make sense, right? Because you'd have to have your hand in it. So it was enough to put doubt in a lot of jurors' heads. And so he was found innocent. He was found not guilty. So that's how I always remember the word acquittal. Because if the glove doesn't fit, you must acquit. And the glove did not fit. And so they acquitted. And they acquit. And they found him innocent and stuff like that. And so the person will be released. If the jury votes the defendant is guilty, they go on to be sentenced. And then sentencing. So each case is unique. Even if it's the same crime, it's different. Like, who was the victim? What's the background of the person who did it? You know, like, is this a habitual, like a repeat offender who does it over and over? Is this just like a one-time person who made a mistake? Was this like a passion? Was this just like a stranger? Was this someone they owed? Like, what was the victim? What was the relationship? They look at all those different things. So yeah, murder's murder. But like, there's so many different factors they would consider when sentencing people. And people can get two different sentences, even if they both just quote unquote did the same crime, like murder. One person get this, one person get that type of thing. They consider like the person's family life, their criminal background, records, stuff like that. Victims are allowed to speak, talk about maybe the pain and suffering and trauma they went through. And they're trying to do that in the hopes of like getting the person a worse sentence and stuff like that. And then as you learned about with Miss Fadley, the way that the court systems work, if it's federal, from district to appeals to Supreme, it's state from like district and superior to appeals to Supreme. What happens is someone loses, and the person who loses, they're not happy they lost. Nobody's ever happy they lost, whether it's the prosecutor or the defense, whether the person really did it or they didn't. They're not happy if they were found guilty, and so they're going to appeal. The prosecutor's not happy that they think that this bad guy got let go, so they're going to appeal. So usually nearly all cases are appealed to a higher court, to the Court of Appeals, to see if some rights were violated or the trial was unfair or something like that. A lot of times it's not, and the original decision stands, but that's always kind of one of the like last steps afterwards. All right, so that is it for criminal, and I will do another video for civil. See you guys later.